When seeing news stories of shootings where race plays a crucial role, for example, the killing of Trayvon Martin or Ralph Yarl, it becomes easy to believe that these tragedies are normal or new developments. But Carol Anderson's essay on self-defense in the 1619 Project emphasizes that the unfair utilization of self-defense laws in America is not something unusual, but is something that is deeply rooted in the nation's legal system. Anderson traces its origins all the way back to slavery and systemic racism to reframe what many Americans believe about the right to self-protection and to bear arms. This chapter is a vital reflection on the long history of gun laws being shaped by the aspiration to control black bodies and protect white lives. In the beginning of the essay, Anderson mainly talks about the hypocrisy of self-defense laws when it comes to the Second Amendment. A prime example of this is the case of Jesse Murray Jr., a black man who retrieved his gun to protect him and his wife, who were being harassed by Nathan Adams. When he came back, he was attacked by a group of white men and accidentally shot his gun, killing Adams, who turned out to be a former police officer. On the other hand, George Zimmerman, a 28-year-old Hispanic man, stalked a 17-year-old boy named Trayvon Martin, walking through a gated community who was doing nothing wrong. Zimmerman called 911 in an attempt to get him arrested, but when he realized they weren't going to do anything, he took matters into his own hands and ended up killing Martin with no justified reason. Now what makes these two cases different is the outcome of their trials. Both Murray and Zimmerman relied on the stand your ground law to protect them, but only one was able to walk away freely. When both were on trial, Murray was given 5 years of probation because he wasn't defending himself, while Zimmerman was able to walk away freely even though there was no reason to defend himself. Looking years back at the War of Independence, the idea of armed slaves left states in the South feeling very unsettled. President Washington constantly asked the states to let the enslaved men contribute to the fight for their independence, but the states' resistance against it just grew stronger. This led to the Constitution Convention, which attempted at freeing slaves but ended up unsuccessful and led to 20 more years of slavery, along with many laws to go behind it. About 10 years after the Constitution was passed, many northern states worked to become more progressive and helped abolish slavery for good. Black Americans were left incredibly vulnerable after slavery ended, despite being free in theory. Racial violence was frequently ignored or actively encouraged by the state, local police, federal government, and courts. Black people were consequently unable to depend on governmental institutions for protection. Till this day, hypocrisy against Black Americans in terms of law, self-defense, and their rights have been ignored and looked at as unimportant compared to white Americans. Many people and organizations have worked to change this view, such as the Black Panther Party, NAACP, and many notable civil rights activists. But even with all the progress we've made, the many parallels we can draw from then and now shows how we never truly escaped discrimination, and the ability to be seen the same as a white American will never truly happen.
This self-defense essay, unfairness towards African Americans and their rights in today's society, is still highly prevalent. The Stand Your Ground law, created by the National Rifle Association in 2005, gives a person the right to justifiably defend themselves when they are faced with a threat if he or she believes that such force is necessary to prevent injury or death to themselves. Nikole Hannah-Jones uses multiple examples of African Americans using self-defense against a white attacker, but the Stand Your Ground law wouldn't apply to them. This happened in the past and continues to occur in the present. In 1944, Lena Baker, an African-American woman in southern Georgia, shot white man Ernest Knight. Knight had forced Baker to come with him to his grist mill, then locked her inside, and when Baker tried to leave, Knight pulled a gun on her. They fought over the gun, and it went off, striking Knight in the head. In court, Lena Baker said she used self-defense, but the jury took less than half an hour to declare her guilty and sentence her to death. On April 2nd, 2025, during a high school track meet in Frisco, Texas, Carmelo Anthony fatally stabbed a 17-year-old student, Austin Metcalf. Carmelo, a student from Centennial High School, was sitting under Memorial High School's athletes' tent when Austin Metcalf and his twin brother, Hunter Metcalf, asked him to move and leave the tent. Anthony warned Austin Metcalf not to touch him, and Metcalf pushed him out of his chair. This led Carmelo Anthony to pull a knife out of his backpack and stab Austin in the chest. Carmelo claims he acted in self-defense because Metcalf had assaulted him first. Anthony's trial has not yet started, but the court will likely ignore the Stand Your Ground and self-defense laws in Texas because he's African American. Being self-defense forced us to get a better understanding of how the American law and our right to self-protection is shaped by race. Before reading this chapter, we knew there were many flaws in the justice system, but Hannah-Jones took us all the way back to the root of this problem and told us about the history within the flaws of the system. It helped us comprehend more fully that laws like Stand Your Ground and the Second Amendment have never been equally applied to all races. Most people believe that racial injustices only happen in the past or in some rare cases, but after hearing about the long historical line from slavery to today's self-defense laws, it just shows that these problems are deeply built into the system itself. This challenged some of our assumptions about progress and made us realize that these conversations about gun rights and self-defense cannot be had if people are not taught the knowledge behind it.